Many thanks to Professor Arcidiacono for this very interesting presentation, for this analysis of the topic of the average online consumer from a very original perspective. I found interesting your speech, and I think this analysis could be used also in other fields of the competition law, for instance, the regulation of the unfair commercial practice. Okay, this presentation ends the session regarding the AI and the industrial property. I ask you whether there is some question or intervention? No? We can move to the final remarks of Professor Di Cataldo and Professor Arezzo.
Thanks, Michele. We are at the conclusion of this day, so intense and full of ideas. I'm supposed to say few words of conclusion, but to say the truth, I don't think I could do it. Not only because it is quite late and we are all a bit tired. The main reason is that it's, in my view, too early to reach now some conclusions. The study of artificial intelligence is in its first days. It must go on. We can wish to arrive to some conclusion later on in the future. This is my wish to all of us. I prefer to give the floor to Professor Emanuela Arezzo. She has perfectly organized this conference, giving us a very interesting occasion of collective study and reflection. I'm sure she can give us some more ideas on this new world of AI. So please, Professor Arezzo, you can take the floor and give us some minutes more, not too many, of course, of discussion on some of the many points of the new law of AI that still need to be studied.
Maybe.
Please.
Thank you, Professor Di Cataldo. Before giving you my few concluding words, I would like to thank not only the speakers, which have already done, but also my team, who's been really, really kind and supportive. So Martina Cavaliere has been already mentioned several times because she drove here a few speakers, but I also wanted to thank Dr. Benedetta Buzzelli and Francesca De Luca, who are two PhD of mine, who have been also very active on the organizational side, and you probably have received some email from some of them. And Sanseverino, who also been a driver, even if just within Teramo. All of my helpful team, and I wanted to thank this. There's a student who resisted up to now, so he gained the exam. He's a very, very valuable student. So now I'll try to summarize, although it's very difficult because we have seen so many interesting thoughts on different angles. As I was saying at the beginning of the conference this morning, so AI is capable of doing different things. We made different functions. We started from the area of commercial law. We still have two of the speakers of the session today. And here we analyze in commercial law the application of blockchain to digital shares. We've seen already many things that we can already do thanks to AI in the broad sense, in the sense of giving us the possibility of certify certain action and circulation of shares online. We've seen already, however, some risks of AI, and Professor Latella was explaining how when it comes to the use of AI as a tool within the corporation, we still have many shades. We can see already the possibilities, but we also see some problems in how we can be sure that those systems that offer us valuable options are not biased, for example. So then we have also considered downsides and then the liabilities, and this all still, it's on a very embryonic stage, I would say. We still have to test it more deeply. And then we went, for example, I've read the recent papers recently also on the possibilities about how AI can also be a tool to have the directors be more prone to take sustainable decisions, for example, but we still have to test how this will happen concretely. So turning to competition law, we have seen also here many possible future scenarios, but here the scholars and Dr. Pizzoli as well have analyzed maybe more the risks than the pros at the moment. We still navigating through very uncharted waters, so we are still here in a stage where we see the possibilities, but we are also afraid that on the one side, access to big data and then to computational analysis may be just a disposal of big firms. So we are tackling here also the risks and the possibilities for the future. And then when we turn to the realm of intellectual property and then at last industrial property, we turn to different angles again of intellectual property. So in corporate law, we are very fascinated about the predictive capabilities of AI, the capacity of AI to take decisions autonomously. In the realm of IP, we are tackling the generative side of AI, so the capacity of AI, the ability to create content which can be somehow related to copyrighted content, to inventive content. Can it be considered this output inventive or creative? So, of course, we tackle different issues. So lots of questions. I don't have, of course, the answers, but we have some answers provided in the law at the moment. Although we might like it, we might not like it. We've heard a very interesting presentation by Martin from Remote, by Christophe, and by Thomas, because now, of course, there is a hint, whether we like it or not, in the AI Act that said we have to respect the authors. The authors can opt out. Of course, it's a very broad norm, so still we don't know how they can and will opt out. But the authors' rights are there, and the EU legislator somehow has decided that they have to be somehow compensated, whether it will be at the training stage or whether it will be afterwards. But those rights are there, and we will have to recognize that. Also, a provision that has been quoted by many of us today, lastly, I think from Thomas, was the obligation to disclose this set of contents that are used for the training. I just want to rely on this because I think this transparency obligation is very important. I think transparency is an issue that cuts through the different areas of commercial law. Because from the side of copyright, of course, transparency is needed because we need to know what the data set is composed of, and then to protect the authors to see if some content has been taken without author's consent. But I think transparency is a fil rouge because it's important, for example, also with regard to commercial law, because again, the algorithms are not transparent, and if they're not transparent and they have this opacity, then we cannot trust them. And if we cannot trust them, we cannot test them. Then it becomes more difficult to fully embrace the possibility they offer within the board of directors. So transparency is a very important point, and is also an important point in patent law. So we were addressing now the Dabus case with patent lawyers have, of course, heard about Thaler's stories all the time. So we have these last very important cases where the court have said in the UK, now in German, well, of course, the AI cannot be named as applicant. Which I totally agree with, but on the same time, this poses another question. So, okay, it cannot be the applicant, it cannot be the inventor, but should there be an obligation to disclose that the AI has been used in the first place? Because inventors could be tempted to say, okay, I'm not going to say that I used an intelligence system, I'll just say I'm the inventor, and then this kind of trumps the all analysis of whether the invention is obvious, it's inventive enough, etc., etc., etc. So also transparency in this regard, it's a fascinating topic. And then, of course, we include AI in the invention, then we have to decide how we put AI into the content of the investive step assessment. So this is another very important link that cuts through all those areas of law. Just to conclude, because I think we're all very tired, about copyright law, I just want to say a few words because I've wrote a paper on this a few years ago now about the copyrightability of AI-assisted output, which has also been mentioned by, has been broadly assessed by Christophe, and we exchanged already some views this because he listened to my presentation, which was online for a while. A possible view could also be to explore some sort of neighboring rights. It's a very difficult route, of course, and it's a way of adding another property right, so many are against it, of course. But I think we are going towards a future where AI systems will almost become softwares in the way we use applications on our phones, on our tablets, and we will use it in our daily life. So there will be a demand for users of those systems to have some sort of protections of the creations that they realize, creations within brackets, but the output they realize. And some of them, as Christophe has showed, are even fascinating somehow. I also like the picture that won the prize in San Francisco. I think that's a quite impressive picture. And also the engaging of the person in the creation of the final output is getting more and more sensible. If we just put in a request in the prompt, then the result is going to be very, very different as compared to the result given by the continuous interaction of the user with the system. So maybe a little protection could be given, but since it's not just human creativity, but it's mixed with the intervention of the machine, maybe we could think about a different instrument to give that modicum of protection that the user wants in order to publicate, for example, or just post on his social network the result that he has created to share it with friends, and it doesn't want to be just straightforwardly copied by third parties. So maybe that's a route that we can explore further in the future. But again, I just wanted to say a few words. I think we're all tired, so I will just cut it in here. I, again, thanks all the speakers for being with us, for sharing their thoughts. There are actually more questions than answers, but this is only one event. We will then probably come back on this in other occasions. Thank you again.